Under the fictitious Waste Management Act 2021, a local commission approves the construction of a heavy industrial incinerator exactly 200 meters from Rihanna's front door. The site guarantees emissions will drift directly over her property, posing a severe threat to her respiratory health and rendering her home largely uninhabitable. Rihanna's rights are clearly engaged. But for a law student looking at this fact pattern, the immediate challenge is procedural. How do you legally vindicate those international human rights within a UK domestic court? To answer that, we look to 1950, in response to the atrocities and absolute devastation of the Second World War. The Council of Europe drafted the European Convention on Human Rights. The goal was to establish a permanent baseline of civil liberties. For decades, however, enforcing those rights was incredibly difficult. If the UK violated a citizen's rights, that individual had to exhaust all domestic remedies and then petition the European Court of Human Rights in Strasbourg directly, an exhausting process that often took years. Parliament solved this by passing the Human Rights Act 1998. The HRA incorporated the convention rights directly into UK domestic law, avoiding Strasbourg. Knowing the history isn't enough. High marks require you to execute a flawless sequential statutory analysis. You must use the exact mechanics of the Human Rights Act. You must demonstrate that the HRA is the specific transmission mechanism bridging those lofty international principles with rigorous, enforceable domestic remedies. This flowchart represents the cognitive map to solve any HRA question. You start by identifying the defendant acting as a public authority under Section 6 and establishing claimant standing under Section 7. From there, you categorize the specific right, apply the justification test if the state claims interference is permitted, and finally, select the precise statutory remedy available under Sections 3, 4, or 8. Do not skip or reorder these steps. If you analyze the breach before proving standing or suggest a remedy without categorizing the right, you destroy the logical sequence of your legal argument. Adhering strictly to this structural roadmap is the defining difference between a standard pass and a first-class mark. Let's apply it to Rihanna. The first major hurdle in your problem question is properly identifying the defendant. Section 6 of the HRA states clearly that it is unlawful for a public authority to act in a way which is incompatible with a convention right. To prove the defendant qualifies, cite the Court of Appeal in Beer. They ruled that the terms public body and public authority are synonymous. If the decision-maker is subject to standard judicial review, they are a public authority under Section 6. Once the defendant is locked in, you pivot to the claimant side of the equation to establish standing. Section 7 stipulates that a person can only bring proceedings for breach of a convention right if they are a direct victim of the unlawful act. Pay close attention here. Do not apply the broad sufficient interest test used in standard judicial review. The Section 7 victim requirement is entirely separate and much narrower. Because the claimant must be directly and personally affected, political organizations and pressure groups generally lack standing to bring Section 7 claims. There is one very narrow, recent exception to this rule. In Varin Klima Seniorinen, the court granted standing to an association concerning a state's failure to protect lives from the adverse effects of climate change. However, as confirmed in Cannavacciuolo, this is strictly limited to climate change. For localized environmental pollution, standing for pressure groups is completely denied. Applying this to Rihanna, the statutory commission deciding where to build is clearly a public authority. Rihanna lives 200 meters away and will breathe the emissions, making her a direct victim. The first jurisdictional threshold is successfully crossed. With jurisdiction established, we move to step 2, legally categorizing the specific convention right engaged. This taxonomy tree divides the convention into 3 distinct tiers. Not all rights carry the same legal weight. Absolute rights, such as Article 3's prohibition of torture, have no exceptions. They can never be lawfully breached by the state. Limited rights, like Article 5's right to liberty, contain highly specific, exhaustive exceptions written directly into the text, like lawful arrest. Finally, qualified rights, including Article 8's respect for private life and Article 10's freedom of expression, require a constant, active balance between the individual's freedoms and the wider public interest. Returning to our scenario, we have to identify exactly what legal claim Rihanna has regarding her home and her health. The incinerator directly impacts her living space. This engages Article 8. the right to respect for private and family life and the home. We look to our taxonomy and see that Article 8 sits firmly in the qualified tier. Because Article 8 is qualified, Rihanna's victory is not guaranteed. The state is legally permitted to interfere with her right, but only if they can prove their actions pass a strict three-part justification test. This brings us to the qualified rights calculus. To legally justify an interference, the state must clear three sequential hurdles. Hurdle 1. The restriction must be prescribed by law. The state must have a precise, accessible legal basis for their action. It cannot be arbitrary. Let's test this using IRAC methodology with the landmark House of Lords case Purdy v. DPP. The issue: Debbie Purdy, a multiple sclerosis sufferer, wanted to know if her husband would face prosecution for assisting her suicide. The rule is that the law must be sufficiently clear to allow a citizen to regulate their conduct. In application, the Director of Public Prosecutions had no crime-specific policy detailing when they would prosecute. The court concluded this absence of clarity meant the interference was not prescribed by law. This resulted in a violation of Article 8. If the state passes Hurdle 1, they move to Hurdle 2, establishing a legitimate aim. The Convention lists specific permissible aims, such as national security, economic well-being, or protecting the rights of others. Hurdle 3 is the most difficult. The action must be necessary in a democratic society. This requires the court to check proportionality. Does the action go further than necessary? Here, the state is often granted a margin of appreciation, allowing local authorities some leeway in assessing local needs. Let's run a second IRAC on Hurdle 3 using the European Court of Human Rights decision in Sass v. France. The issue: did a French law banning face-concealing clothing breach Article 8 and 9, or did the state's margin of appreciation cover local moral nuances? The rule dictates that where there is no general consensus among member states, a wider margin of appreciation is granted. Applying the rule, the court found little agreement across Europe regarding the specific moral and social implications of the ban. The conclusion? France was granted a wide margin to uphold the rights of others, rendering the ban proportionate and lawful. We apply this calculus back to Rihanna. The state clears Hurdle 1 via the Waste Management Act, and Hurdle 2 regarding economic well-being. But for Hurdle 3, proportionality, if an alternative, safer site for the incinerator exists away from residential areas, building it just 200 meters from her home will fail the test. The state's action is unlawful. Assuming Rihanna has successfully proven the state's interference is disproportionate, we arrive at the final, ultimate question for your exam paper. What remedy can the UK courts actually provide? Under Section 3 of the HRA, domestic courts are given a powerful interpretive duty. They must read and give effect to primary and subordinate legislation in a way that is compatible with convention rights, so far as it is possible to do so. This power goes beyond standard dictionary definitions. In Gaiden v. Godin-Mendoza, the House of Lords interpreted the statutory phrase as his or her wife or husband to legally include same-sex couples, adjusting the text to ensure full compatibility. There is, however, a strict limitation. Sometimes the explicit wording of an Act of Parliament directly conflicts with a convention right. If the language is ironclad, a compatible interpretation under Section 3 becomes impossible. When Section 3 fails, the courts turn to Section 4. The higher courts have the power to issue a formal declaration of incompatibility regarding the specific piece of primary legislation. Listen carefully. A Section 4 declaration does not invalidate, strike down, or pause the enforcement of the act in question. It generates intense political pressure, triggering a fast-track procedure allowing the government to amend the law. Draw a crucial distinction here on your paper. While the court cannot strike down primary acts of Parliament, incompatible delegated legislation, like ministerial orders, absolutely can be quashed by the courts. Concluding Rihanna's case, the incinerator was authorized by the Waste Management Act, primary legislation. Therefore, her ultimate victory in court will result in a Section 4 declaration of incompatibility. This leaves the final fix up to Parliament. Let's recap your mental model. Identify the public authority under Section 6. Prove your claimant is a victim under Section 7. Categorize the right in the three-tier taxonomy. Run the state through the justification calculus. Finally, apply your remedies using Sections 3 and 4. The ultimate examiner's red flag. Never advise a client that a UK court will strike down an act of Parliament under the HRA. The HRA was deliberately engineered to preserve parliamentary sovereignty. It separates the judicial power of interpretation from the legislative power of invalidation. Master the statute, respect the hierarchy of rights, and keep your analysis rigorously sequential. Stick to this framework, and you will conquer any HRA problem question thrown your way.